I'm going to have a couple of words for our online audience in a moment, but this is for them and especially for us. Many of you might have heard on the news that a Marstonville police officer was shot this evening while serving a warrant. And I've just been told that the news reports say that he passed away.
Oh, boy.
So let's start off, if we may, with just a moment of silence and a little prayer for this fellow. I don't even know his name, but in the line of duty, protecting us, he's paid the ultimate. So a moment of silence, please. Thank you very much. Well, that's a down note to start a meeting. We have a nice group here tonight. Before I forget, like I always do, and then I'll have an announcement. Can we please rise? Let's say the Pledge of Allegiance. I think I'll lead it this year. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. So everybody who's a regular here in the class, I think we have a new face or two. So this will provide a little information for you as well. But for our online audience, We the People of Cape Cod is a 501c3 nonprofit educational organization. I've been talking for quite some time about a new website. It's slow. We're all volunteers here, folks. But we finally have made public our new website. It's embryonic, but we do have some archive footage of previous lectures, and we'll have more up soon. You'll soon be able to see other video and share other educational content, no matter where you are in the country. There are essays from Hid Welch's book, A Citizen's View, and you can also purchase Hid's book directly to the website. If you want to buy it through the website, every book that's sold, this organization, We the People of Cape Cod, gets $1 from the purchase price. And let me just point out one or two other very, very important pages on the new website. So first of all, it's over here, WTPOCC.org, We the People of Cape Cod.org. And there are two pages I would like to draw your attention to, particularly the people that are watching us online tonight. One is the subscribe page. There's a $25 a year tuition that people in this classroom pay. It doesn't rival Harvard or Brown, but 25 bucks gets you in the door. On the website, you can go to the subscribe page, and you can watch as you are now. And we're just asking you to make a contribution of 99 cents per month. Put it on your credit card, do it right online. Or if you want to do it for the whole year, it's 10 bucks. So you save $1.98. I would recommend the full year subscription for 10 bucks. You can also go to the donate page, and organizations like this that start off small, we need a little bit of a bank account to do the things that we want to do, to have good speakers, recruit them, in some cases pay for their airfare, and so forth, and buy literature, produce literature. So for those of you online, and for you in the classroom here, who have already paid your $25 dues, if you would like to make a donation to We the People of Cape Cod.org, please go to our donate page. You're going to see some very nice, high-quality lectures in this group, and it's not highly produced. This is a class, and we're very glad that you're able to join us. So tonight, we have Dr. Rod Rodriguez, who's the principal of New Testament School in Plymouth. He's an attorney. He's an author. He's a historian, and a great guy too, and a good lecturer. And he's going to talk to us tonight about on the topic of well, the title is Stray and Pay. And what's happened is over the course of years, we've strayed a little bit from our Constitution. There are people who would like to interpret the Constitution a little bit more than perhaps it should be interpreted. And often,
that doesn't turn out so well. And so stray and pay, the consequences of over-interpreting the Constitution. Dr. Rod Rodriguez from the Testament School. Thank you, Rod.
Well, thank you. I want to welcome everybody here tonight, and it's wonderful to be with you. I look forward to this. I kind of want to share with you a little bit of the background, kind of give you a little bit of a roadmap of what I want to do. Is if you're over 40 years old, if you understand that there's been a radically different way in which we approach the Constitution generally in society, particularly from professional judges and attorneys and such. Let's look at the time. And there's been a departure from the discipline of letting words mean what they actually say and following the actual text of the Constitution. And that's because there's a theory that the Constitution is a living, breathing document that always evolves. And sometimes those on the bench feel that they're anointed enough to tell us where we're evolving to next and kind of speed things up. And usually we take a hit for it. And it undermines the very authority of law, the sanctity of law, because nothing is as sure anymore. So with that, I want to share with that, but I'm going to turn at the last part, if I have the time, and then focus on what I think is a little more cutting edge. I want to show that where we've been and where your organization is trying to offset this kind of theory that rights aren't set in stone, that they avoid the people by interpreting whatever they feel is best for society from the bench, avoiding the legislatures, and in fact, avoiding you. I want to look at how the very thought of disciplining oneself to actually define terms and maintain a definition is creeping to a point that there's a total breakdown in it. So your organization, in light of that, is going to be extremely important, but it's also some bad news. You're going to have a tougher time than you think. So with that, let me get started with this idea now. The opening statement is going to be, I'm going to read somewhat because I thought this through, and it's a little bit different than what you may hear. But in the end, I think we'll tie it all together. Now listen closely to this opening paragraph. The Constitution gives us no substantive morality. It does not claim to be a moral code. Rather, it presupposes faith and morality on the part of the people. What this means, therefore, is that the defense of the Republic is not legal or constitutional, but rather based on the faith of the people, what the people consider sovereign. That's a key term. Whatever the people consider sovereign. That which is sovereign will determine the meaning of the text. The integrity has been broken down to a point where if that individual believes that they're entitled to be sovereign, then they'll interpret the text according to the dictates of what they believe is right or wrong, forgetting any oath or forgetting any duty to declare what the Constitution states or let it speak for itself. This slow shift of sovereignty from a transcendent basis of law, including the high regard for individual liberty, rooted in self-government, to the modern transfer of sovereignty toward a centralized, monolithic state, is a new radical shift in national faith. This new sovereign, the state, corrupts, perverts, and ultimately renders the Constitution useless to its original intent. This Constitution that elevates the individual liberty, that's there to protect originally our property rights in things, our opinions, and reduces one and all property to the service now and slavery of the centralized state and this bureaucracy. And in other words, as the faith or the character of a nation changes, it will then degenerate, and it will cause all things in society to begin to degenerate and devolve, whether it's even the language or the definitions within your textbooks or Webster's dictionary. Twisted meanings today exist concerning every clause of the Constitution, and actually we could speak all night of how this process of this evolving standard, or this idea that the judges have been cut loose from the law itself and they alone are the anointed that can interpret the Constitution, has so wreaked havoc on issues like the Commerce Clause, the General Welfare Clause, and even the magical incorporation of the 14th Amendment and the phantom-like, what they call penumbra of rights that are just picked out of the air. They're nowhere in writing, they're nowhere declared in the Constitution, but they somehow pick them out of the air because it suits the political philosophy or the personal philosophy of the judicial wranglings. Or, as I'm going to concentrate on tonight, the Fifth Amendment as it relates to what we call the takings clause in cases, because property is extremely important. With that, since we're going to talk about the Fifth Amendment, I'll pull out my little handy dandy, and I see these are on the table. I want to read the Fifth Amendment, and I'll go quickly to the first part, and then I'll slow down because we want to focus in on the last clause or the last part of it. So with that, let me begin. The Fifth Amendment. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life or limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, or property, and here's the key point, without due process of law, nor shall private property be taken, mark that term, taken, for public use without just compensation. So what we want to do is review and notice the terminology of the Constitution, what it meant to the founders at that time, and how it's been corrupted by different approaches to law and life, all right? So with that, we want to consider that original intent on the following terms from a historical perspective. Terms such as, the key terms in this case, taken, public use, and just compensation in light of recent modern interpretations. Notice the term chosen by the founders was taken, not eminent domain. There's a significance to that. The language eminent domain does not appear, and yet today, that's all you hear about when they're widening a road or they want to put some kind of easement, or in the older days when we're looking for railroads to connect the oceans. What you saw at a time period prior to roughly the 1870s in those railroad cases were what they call the takings cases. Literally now, since particularly FDR, they've been switching, and now you hear the language eminent domain, and there's a reason for that. Because remember, we said that ultimately the interpretation of these words is whatever is the fundamental belief system of a people, what they believe is right, wrong, what is proper to a citizen. In other words, it's the people and the culture itself that confine and restrain and pressure society to make sure that there's integrity or no integrity in whether a word really means what it's supposed to mean or what it says it means. So looking at the taking clause, we know that it presupposes a prohibition against the government in regards to property of private citizens. And in other words, the state doesn't have an ownership right in the property, because if they want to have access or they want to be able to have power over it and they try to seize it, it is called a taking because it presupposes the individual owns it. So the state must do something in order to take possession of it.
Don't you find that under Article 1, which builds of the king?
I tell you what, I'll address some of those things at the time of the questions, if you don't mind. I want to see if I can get all this in. Since the role of government at the time of the founding and until recently was to protect the property of private citizens from theft, this precluded the government from taking property unless for the limited purpose of public use accompanied with just compensation. Otherwise, the state renders itself a thief without any recourse for the private citizen. They can do what is at will. And in other words, the term eminent domain is very foreign, and we're going to get to that, and I'm going to define it for you. Again, consider the railroad cases prior to the 1870s. They were referred to as takings, not eminent domain. In fact, the term eminent domain, or the idea of what we understand today as what the government can and cannot do concerning private property, begins to take form roughly around the 1890s. But prior to that, there's a change. Now, this change begins to happen just prior to the 1890s with the Civil War. And we'll address that as well. But first, let me tell you about the nature of property, which is your heritage, which is your right as an American. In America, originally, all property was held in what we call a allodial form. Allodial form, which meant that total ownership free of rent, a freehold estate without any acknowledgement of a superior. Do you hold your property like that today? Now remember, America has such a strong foundation that in order to corrupt the system, in order to change the system, it literally takes generations. It was a chipping away because of the strong heritage we have and the high view we have of property. In America, we always said that a man's home is his castle. Well, you know, it came off the tip of your tongues very quickly. The younger generation, that's lost. They don't understand that. You don't quite hear that as much. Although my generation and previous generations, we can be as one in that idea and that view. England is one that holds or understands this idea of eminent domain. England has no such principle of allodial property, especially since the Norman invasion. Now, the king holds the property in theory, and what we have is eminent domain remains ultimately with the state. And in other words, the dominion of something is most closely imminent to the state, not the individual. So dominion then, yes, sir.
The word allodial?
Allodial.
Hey, you spell
Sure. Allodial.
Thank you.
And that was really in place up until about the time of the Civil War. So for a while, we were maintaining that type of property rights, and they were constitutional. That was in line with what the Constitution had in mind. Now, dominion, again, is the rule, the control, the authority, or the first position would lie with the state, not the individual. There was an obligation between you and your full control of the property, and that would be the state. And it is feudal in nature. Rent can be applied, and ownership is conditional upon the duties or services to the crown. Well, we call that today property taxes. What happens if you don't pay your property taxes? So you have more enhanced rights than a general renter, but you don't have allodial property rights anymore. They've been eliminated. The loss of property rights in America, we could trace to the trends roughly the 1800s or what we say the 19th century. Before the Civil War, as stated before, basically we retained the original intent or the words of the Constitution. Post-Civil War, as a trend, we began to depart from the original meanings, and there was a rise of socialism. Now, we didn't see it as that as such, but we set it in motion because if you recall, an amendment was added to the Constitution that no longer allowed the governors to choose their senators. They wanted to weaken the Southern governors in order and dilute their power, and therefore the senators were no longer corporately responsible to the needs of the state. They were now directly to the people, but you lost the balance. There used to be, just like in the House and the Senate, there used to be a corporate representation, and then the individuals were represented by the House. There was a corporate representation in the Senate. You had that build a structure overall between the states and the federal government, and that allowed the federal government now, over time, to gobble up more power because it removed a safeguard against its encroachment and its expansion of jurisdiction. The progressive movement was an indirect attack on private property, and it accomplished this through zoning laws, a regulatory philosophy they began to chip away. Environmental laws, protecting the environment from people, technology, and business. In fact, the first Conservation Act roughly came around 1891, and then old Teddy Roosevelt would form a lot of national parks, and he would begin to utilize these powers. At first, what seems to be good violates a principle of property to the individual that we begin to pay for later on as we become more corrupt, as things become more tainted. There was a direct attack on property ownership called property taxes, income taxes, and then suddenly certain assumptions begin to take place, and the language to reflect the change in the educational culture or the practice of law begin to surface, and we started to see appearing eminent domain rather than takings. And remember, takings presupposes something belongs to someone else, and I'm taking it, therefore I cannot steal. To take, I must what? Pay justly, and there must be a reason that's justifiable under the limited purposes that are enumerated in the Constitution. But once this idea switches, once this vacuum of power goes centralized and the flow of power is no longer from the people upward, from the bottom up, or from the top down, it's like a vortex that just sucks everything in. And it starts expanding jurisdiction, and it gives itself more and more power. And in other words, the government acts as though it owns your property, but you got to maintain it. You got to mow it, and you make sure you pay your fees. So now we get to the term public use versus public purpose, and how this relates to a feudal view in the old world, a view of ownership of land. The slide towards this socialism corrupts the educational faith of the legal profession, and they're going to be further along in the corruption than the general people. Socialism, expanded jurisdiction, makes what once was private, now listen to me, what once was private with jurisdictional rights now becomes public. There's more and more things that we looked at, we separated and put in the private category that now gets gobbled up by the state because it's expanding its jurisdiction. And with it, it grabs more property rights, more power. And what it does is it makes what was once again private, public. And if it's made public, well, then it's a matter of the state, and it can be what? Touched. You see, what used to be out of the reach of the state now becomes part and parcel with what we call public, what used to be private. And it's this philosophy, this idea, this view, this interpretation of these expanding rights and these evolving standards, so to speak. So as the jurisdiction expands, as once what was private now becomes public, all things can be now rationally related to a public purpose. There's almost nothing outside the reach that the government says doesn't somehow rationally relate to a public or governmental function. And they're very creative in the way they interpret. Okay. So now we have the trickle down from the 1890s. This movement gets a head of steam, very powerful, with the FDR administration, who writes numerous executive orders to implement the takeover of public works and utility projects and other works projects during the Depression and early 1940s. That takes us to Kelo versus New London, Connecticut. Now, we have to talk about that, and also in the background, in the shadow, that going back to Kelo, that was ruled in June, before the Supreme Court, June of 2005. And the Hawaii, which was another horrific takings or eminent domain case, came out of Hawaii, the Hawaii Housing Authority versus Midkiff. That was 1984. So they've been chipping away and chipping away. So let's take a look at generally what was done here in the takings case. When you say public use, there cannot be property where somebody in the United States, if they so choose, can drive down or enjoy that public library, or something that is enjoyable or vested in the people altogether generally. That means that property can be taken for these very limited purposes to serve the community in some way, but that everybody would have a right. If it's a widening of a road, technically, if it's here in Massachusetts, probably somebody from Hawaii wouldn't use it, but had they visited, they could drive down that road and they couldn't be stopped because they weren't a member of the community. So there's this idea that the land is then taken in trust for the service of the entire community, but it's never to be transferred, here's the key, to a private party. Because if it's transferred to a private party, what we really got is Marxism and communism in disguise, the redistribution of property. The state decides to play the game as to who's more deserving of it. So in this particular case, what we had is a piece of property that had been owned for many, many years. And this isn't the only case like this. Since then, this has happened in other areas. And as you know, this happened in Florida, where I'm originally from. We have a lot of elderly move down to Florida. And sometimes they buy a piece of land, and then all of a sudden, Florida values go up tremendously. Prior to the crash in 2008, 2009, the real estate market, it was going through the roof. And what was happening is that as they revalued these properties, you had a lot of people living on fixed income, and their property taxes were going through the roof, and they no longer could afford it. So that's pretty an embarrassment that you're having to move elderly people because they no longer can afford the taxes. So a law came in to say what we're going to do is we're going to grandfather you in a certain value, and they can only go up very, very slow for so many years, and then they cap off. And if the transfer of title happens, that the house is sold, then you can reassess it and give it a stepped-up basis. So that protects the individuals. Well, what happens here is these pieces of property, sometimes they're on the waterfront, and what used to be a depressed area becomes the new hot area, and they've got this piece of land that's been there and owned by somebody for 40 years, and they're not collecting much property taxes on it because of the law. It's been capped. However, if it's developed and they put 400 condos on that, now they can bring in a whole lot of revenue. However, it has never been historically seen that tax revenue or tax-based increase is a public use. Unless, of course, things are redefined because you've got an expanding jurisdiction of the state to such a point that now the state is giving all kind of welfare benefits, all kinds of things that are related to social programs. And because of that, because they're more involved with what was traditionally private, now they can rationally relate the increased tax base as what? A public use. They redefine it. You follow? So now, glad, I love it. So what's happened now is they said, well, what we're going to do is we're going to grant this over not to us taking title as a state, but to a private developer. The private developer now is going to turn around and build these condos or whatever it's going to be. That's going to increase the tax base, and that's also going to probably create jobs. However, the problem is this: that property is sold privately, and that means that that individual can stop you from what? Stepping on his property or coming through his door. It's no longer for the general public, is it? It's not owned in common by all of us. It's not for the benefit of us all. And by taking private land and brokering it to another private individual, in the past when we took land for public purposes, let's say we were building a library, we only paid that builder a profit for the materials and the labor to build that structure. But now this person, this developer, gets to build this property, increase the value, and not only get paid on their labor and their materials, but also the new basis of this property. What the profit will be tremendous. So now what you have is something akin to why our founders, and particularly right here in Plymouth, not just over the bridge, why the Pilgrims came here, because we're trying to avoid mercantilism, where the government gives a monopoly and goes into a favored relationship with a private business. And you know what happens. There's always corruption in that. And it's never for the betterment of the citizen, is it? And it also increases costs because palms need to be greased. You see what I mean? Let's be real. So we've got a whole different corrupted system. So public use has been changed in its definition to suit the needs of a corrupted idea of philosophy of government. Then we have the idea of the just compensation. This one's tricky. I actually worked in the area, eminent domain in Florida, when they were expanding the I-4 corridor from Tampa to Orlando. What happens when a private individual owns the land, and maybe he has some cattle, some cows on it? What you do is you determine what that property can be worth if it's developed according to its location. So it might be a prime location, and the gentleman says, well, I bought the land and I do have a few cows on there, but I really wanted to build a McDonald's there. And if a McDonald's is built there, then it's really worth blankety blank for the location of a McDonald's. But you see, that's exactly what the Kelo case understood, that when we build these other kind of structures, what's going to happen to the value? It's going to go through the roof, and it's going to be a real what? Windfall tax-wise. However, Mr. Owner of that land, we don't want to give you the value of what it's really worth as a developer, but what it's worth now laying dormant. So we want our cake and we want to eat it too, and no longer is there just compensation because there's no longer a real tie-in to what the fair market value is or what a developer would want to do. See, we own, as an institution, my school, 16 acres that are right down the street. Now, the developer wants to build around that, and we have a small easement, and we can get a wider easement. It turns into a very valuable piece of land. Now, the government may want to, I'm just hypothetically playing, they want to get it for $15,000 an acre, as though it never has any of its finished potential, but yet they want to have the benefit of, because by regulation itself, it has the right to declare a easement. They have a lot less trouble doing it than a private citizen, and suddenly they have a windfall on a tax basis. They've got a property that is gone up 100-fold in value. So that's not a fair market estimate. And also, that means that I want an independent appraiser that's not a government employee. But in the Hawaii case, the government came in without an independent appraiser, states what the value is, and says, take it or leave it. Even though the other side went and got independent appraisers to say it's worth a heck of a lot more, even in the state and condition it is undeveloped, than what you have offered us. But they used power. And they perverted the just compensation clause. So now, if you don't mind, I'd like to visit for a second the opinion of Justice Thomas. He dissented in the Kelo case, and I just want to read a little bit of his dissent. It says, long ago, William Blackstone wrote, the law of the land postpones even public necessity to the sacred, he uses the word sacred, rights of private property. The framers embodied that principle in the Constitution, Thomas continues, Justice Thomas, allowing the government to take property not for public necessity, but instead for public use, because public necessity, they can always create an emergency. They can always create a need. But it has to be for public use outside their grubby little hands, right? Public use. And suddenly that doesn't motivate them to take as much property. So when we see that it's for public use, it goes on to say, define this understanding. The court replaces the public use clause with a public purpose. Well, with an expanded jurisdiction of a socialistic view of government, everything could be a government purpose. You can always find a reason for a purpose. It goes on to say that the court instructs so long as the purpose is legitimate and the means not irrational. Before they had a high benchmark. It was a prohibition to take unless for specifically enumerated purposes. But now they corrupted the definition of terms to such an extent through reinterpretation, through evolving standards, etc., whatever the court wants to use as an excuse, that now it's almost impossible, if they want your home, to keep their grubby hands off of it. You are safe within your home, but your home is not. It is no longer your castle. Goes on to say that the differential shift in phraseology enables the court to hold against all common sense that a costly urban renewal project whose stated purpose is a vague promise of new jobs and increased tax revenue, referring to this case, the Kelo case, but which is also suspiciously agreeable to the Pfizer Corporation, is for a public use. I cannot agree, he states, if such economic development takings are for the public use, any taking is, and the court has erased the public use clause from our Constitution. So a little more. Though one component of the protection provided by the takings clause is that the government can take private property only if it provides just compensation for the taking. The takings clause also prohibits the government from taking property except for public use. Let me stop there. Would you bid differently on a property? Would you accept a different amount if they come to you and say, you know, we need your property for a library? And you can go, you know what? That's a wonderful cause for this area. We need a library. You know what? I'll take that amount of money you're asking for, even though it's a little low. But does it change if you find out that they want to kick you out of it and build a casino, a 7-story casino, or a 400-unit condominium complex? Does that change suddenly in your mind the value? This is what he's referring to. So he says that where otherwise the takings clause would either be meaningless or empty once we no longer follow these fundamental principles. And in other words, the clause would require the government to compensate for takings done for public use, leaving it free to take property for purely private uses without the payment of compensation. This would contradict a bedrock principle well established by the time of the founding, that all takings required the payment of compensation. This resembles mercantilism. This is no longer the free market economic America that we thought. Let me just say this last thing. The term public use then means that either the government or its citizens as a whole must actually employ the property taken. The constitutional text, in short, suggests that a takings clause authorizes the taking of property only if the public has a right to employ it, not if the public realizes any conceivable benefit from the taking, which is exactly what it's been manipulated to do. So now, where are we at? How did we get here? Here's where I want to go beyond and get a little cutting edge and share with you that what your organization is combating has really got its hands full. We really got to be educated on what's going on. What we've got to understand is what used to be an evolving standard now has something else attached to it. What used to be just that I moved towards socialism now has a new sickness that kills every single time that's attached to it. And remember, I started saying that it's the people that ultimately defend the Constitution. It's that substance of a belief system, a way of life, a culture that keeps the government honest. Well, what we have is something called postmodernism. And what this book came out in 1987. It was written by Harvard. And what they're saying is in here that there is no such thing as truth. There is no such thing as right. There is no such thing as law. Everything is pragmatism and politics. Now think about that, because now I'm going to go with you deeper, but I'm going to ask you to put your scuba gear on, because I want you to follow me on this, because you've got to understand the consequences of ideas. You take the old adage of just left, right, big government, small government, but you add this theory to it, and it's putting gasoline on a fire. And here's what I mean. There are certain assumptions that the younger generation has, and they're practicing law now. And this philosophy is alive and well in the law schools. And this is how they've been trained, at least for the last 20 years or so. We're starting to see this ugliness come to the top. What we have in postmodernism, it rejects any idea or belief in objective truth. So that means for somebody who is a religious person, there is no truth, there is no God. However, for the individual who was recently called a modernist that didn't believe in God, but believed that we could find truth through science or through reason, they reject that as well. They believe in what is called linguistic relativity, that every single document, every single book cannot present clear, concise, objective truth, that it's done from a manipulative process in order to get you to follow their ideas and manipulate and fool you. And they most often, if they're governmental documents, such as the Constitution, they were done by people that had power and used the tool of the Constitution to simply put you, the minority, in subjection to and slavery to this particular set of people. So the minority, what they do is they suppress the majority. That there is no integrity to language. We can't effectively communicate ideas. They're just simply tools of manipulation to keep themselves in power and to keep you from ever getting any kind of voice. That means that when they look at the Constitution, it's a document that was a consensus in its time and only has meaning in its time because those guys were really bad people that only looked to ensure their power and didn't care anything about your rights. Therefore, we can ignore wholesale anything in the Constitution because none of the words have meaning anyway, and none of them have integrity. Because after all, there can be no objective truth. There can be no rights that extend to you, to your posterity. There is no surety of law. This is applied to all written material. In fact, what happens is a book, the author is dead. Rest in peace. It doesn't matter what the author thinks, only what the reader thinks. That means the judge, doesn't matter what the Constitution says. Doesn't matter what the original intent. Doesn't matter what you think or the other circuit. It matters what they think about the law. So that's pretty contentious in many ways. Now, they do believe in a small subjective truth according to the consensus of the time. Well, that means, and that sounds like a poll, doesn't it? And how accurate is a poll? It's only as accurate as the what? The quality of your sampling base. So you want to get a what? The more wider, the more people participate, the more sure, at least for the time period, we don't know it's going to change shortly, but we have some kind of truth subjectively for a short period of time. The reason I mention that is that the next obstacle you're going to reach is that they're going to subvert the Constitution to foreign power or foreign definitions. And the reason for that is that if that's the truth, and the Constitution says for North America, for this meat and bounds area, that it is the law of the land, they're saying, well, it can't be true, because what we have to do is get a what? Wider sampling base, and we have to know what they're doing all over the world. And whatever the what? World consensus is, will then what? Supplant the supremacy clause of the Constitution, because after all, it's just a document of what? It's just manipulation, political, a pragmatic piece of paper. And it really, there is no fundamental rights that people have, as Western civilization knows it. There's no inalienable rights. Everything is up for grabs. And it can happen very quickly. Now, you also need to know that most of the postmodernists come from the Marxist camp. Remember, the Marxists want to infuse radical change, but they wanted to do it by force. They didn't like the bloodshed, the postmodernists, and also they were disillusioned when they didn't see when the Berlin Wall fell and the communism seemed to be on retreat. They denied the meta-narrative, the overall theme that the proletariat and the bourgeoisie would overcome the bourgeoisie. They said, that can't be true because there is no what? Truth. We just survive from day to day. So now, what do we see in that language? I want to turn these last few minutes. The language that you're hearing on the news every day. I gave you a sheet that was passed around. And what I did was, I got this, I took the students over to the court because they had law day for students to participate and come see. Now, as one that has been in the courtrooms in the past, but I've been away from it for a little while, and coming up here, I went into a different line of work. They had these bookmarkers for law day. This is put out by the Plymouth Court. Now, when I went in there, I was shocked because terms like tolerance, fairness, equality, multiculturalism, which means what? Relativity in cultures. It also, these are all code words: gender equality, acceptance, privilege, white, Christian, etc. And of course, their big famous one, social justice. But social justice now, this is interesting, because of postmodernism, social justice is no longer who solves the problem with social justice? It's always who? The government. So now what's happened is the primary social unit is no longer the family, it is the government. That's going to play a case in the very statistic that I didn't ask them to give us this, they gave me this. And I'm just going to share quickly. But first I want you to notice, and it's kind of dark on to make a copy of this, but as a lawyer, you understand that the role of government or the role of the court is what? The sword, right? Look at the terminology here. Realizing the dream. Tolerance. Acceptance. Inclusiveness. Folks, that's your postmodernism. It's here. It's alive and well. Now, when I go into the court, I got to share the experience. I saw this through a different pair of eyes than somebody that's not in the profession. I go into the first court, and there's a female judge, and she's talking about, she's actually negotiating with a young man who stole a car. And she won't give him time in prison. She'll have him in a home type of arrest type thing. But she's also telling him, when she asks him, do you have your high school diploma? No. Well, if you get your GED, I'll cut this less off. She starts asking about drugs because she wants to put him in a state program. So it dawns on me very quickly, and I said to myself, by the time I get to the second courtroom, because we go from court to court. In fact, let me tell you that one first. We go to the next court, and the only male judge we see in the entire courtroom is that in the courthouse was that judge. And the first thing he tells the students, he says, I have no power at all. I can't change anything. I thought this was kind of neat to hear this. I said, well, what is it that you do? And he says, my job is that when there's a divorce, usually the man loses the house, and he's upset. So I allow him to come in here, and I allow him to talk a little bit, to get it off his chest. So I said, well, the first courtroom, I have a social worker. Now, the second courtroom, I have what? A therapist. You see what's happening? So I thought to myself, I said, at this time, it was Duvall that was governor. I said, you know, I don't agree with his philosophy, but he's brilliant. He never added visibly, they couldn't say that he added new departments and such. He simply retrained the judges to become what? Processing centers to get them in what? An expanded government that wants a drug program, a GED program, abuse program, et cetera, and they begin to negotiate time off to get what? Therapy. Now, the reason that's important, I underlined one section. It says, since 1980, our caseload has shifted gradually from approximately 60% probate and 40% domestic. Now, probate means property, wealth. That means someone died, you have to probate a will if they didn't have a life estate. So you determine where this property goes. It went from 60%, watch this, to now 34% probate cases. 40% domestic went up to 67%. Now this was back in roughly, I think it was these statistics, 2013. I doubt they've gotten better. You know what that's telling you? This is what this evolving idea of the Constitution, this is what this postmodernism has done. Now that the primary social unit is the state, what's happening to your property? It's robbing America of its wealth. That's what's happening. They didn't know I'd use this in that way. It's right there in their own statistics. Because when you see probate cases drop, and you see domestic divorce and all these other things rise, you're talking about poverty and move toward poverty. We're a very rich nation, and we can afford to get away with this for a little bit. But you know, no matter how wealthy you are, if you keep spending money and never make deposits in the bank and just withdraw, there comes a time where you're broke. Well, what are the consequences of this idea to American foreign policy? Think about it. Think about it in the area of immigration. We need a wider consensus. We don't believe in the national borders. So now everybody becomes a what? World citizen, and they have a say, and they don't have to have what?
Citizenship.
Exactly. Do you follow what the disease is? This disease is like a wrecking ball. It kills every time. And regardless of your personal beliefs, where you're at, as far as philosophy, you got to understand we have all one thing in common. This is a sickness that you do not recover from if we don't turn it around. It is the old idea of the interpreting the Constitution as it evolves on steroids. It moves very quickly now. What will it do to immigration, national borders, law? We already talked about that. How about the Constitution? We talked about that. In Constitution, the words mean nothing. Religiously, for those that are you religious, this is the reason why they say the Bible's what? It's just words that don't mean anything. It can't communicate. Or they may say the person who wrote the Bible is what? They were powerful people that want to manipulate the minds of many and use it as a tool. There can be no truth. Think about what this does to education. If this is true about truth and knowledge and no objective standards, will education be better or worse in the future? And you're going to see fewer textbooks because, after all, words don't mean anything. They don't have integrity anymore. You follow? So what we see, if we don't turn this around and we don't pin them down, we have a different type of problem. It used to be, what is the matter of interpretation? But I know that if somebody was on the left versus somebody on the right, they know that they have a different viewpoint as to interpretation. What you're going to get in the very near future is they don't think they're interpreting because they don't understand the distinction between the two, because all of it is politics and pragmatism anyway. That's a different kind of problem. The education in the field to talk to those people to change in the next generation is a totally different animal altogether. It's just not a matter of convincing them of a different viewpoint and therefore being consistent and have some integrity in the interpretation of the Constitution as to what it meant. Heck, forget the Constitution. They don't believe words have any dignity or meaning. Do you follow? This is where we're at. So the future may not be a matter of interpretation or approaches to law, but rather total death to our culture. Truth, morality, decency, or death to the nation. The times are urgent. In fact, I'll say this only, so I put a disclosure on there. I'm a person of faith. And what happens now is this is a direct attack on what we call the Word. The Lord and Savior says He is the Word. In the beginning of John, it says, in the beginning was the Word. And that Word is identified as the Messiah, who is what? Truth. But you see, this is an attack on the Word and the very idea of truth. And if our youth continues to go down this road, not only you're not going to be able to talk about truth in general, you're not going to be able to reach a consensus, because what they do is they become a God in their own eyes. They get to determine, not the author, anything they read, what they want to believe, what they don't want to believe, and what's important is what they think, not what the author is trying to communicate. What a mess. What a mess. Well, that's what I have for you today, and I hope you've enjoyed it and provides something that for you to think about. Thank you.
We have time for some questions, so I'll just let Rod control the floor.
I'm aware of hands. All right.
Okay. Thank you so much for this wonderful presentation. In this great scheme of things, going back to the days when the Constitution was written, there was a clear understanding of natural law.
Mm-hmm.
And I am pretty sure that if we look at today's definition of natural law, it's been corrupted in the same way that you have explained the other. What is your opinion about the importance of natural law as the basis of the Constitution? And going forward, is there any way we can restore that in tandem with it?
I'm not doing this on purpose, but I want to clarify. Let's go back to this original opening statement. It says that the Constitution is not a moral code, but rather a piece of code of faith and morality on the part of the people. So in other words, the understanding of the people's belief system is what's going to now infuse a meaning to the terms. Terms are just terms. What gives it life is the spirit or the substance that fills it. So with natural law, that's a double-edged sword. If you're talking traditionally of people that are primarily, even though not all people were in the nation, but they had a morality based on the Christian faith, let's say, the 1790s, etc. So they knew murder was wrong, lying is wrong, respecting of elders, these kind of things, right? That's what's going to interpret natural law, the term. But from a Darwinist perspective, you could say, well, there's natural law out there in the jungle. I'm watching a special, there's there in Africa, and there's a weak antelope or whatever kind of animal. Here comes a lion, and that's after all what? Natural law. So again, you see, what gives the meaning and the substance, what provides the anchor is that culture of the people, their belief system. So you've got to clarify, you've got to be careful what kind of natural law we're talking about, because that doesn't solve your problem. It's going back to defining our terms. And with postmodernism, it's all up for grabs. It's all up for grabs. Yes, sir.
But there are certain things which have meaning.
Yes.
And in 1790 or
Yes.
when the Constitution was adopted,
Right.
everybody knew what a natural-born citizen was.
Yes.
But if the schools don't teach that,
Right.
and the Constitution doesn't say exactly what it means,
Mhm.
then you can only refer to some documentation which is still available, which spells out exactly what it is. Namely, in order to be a natural-born citizen, both of your parents have to be U.S. citizens at the time of your birth. But if you ask anybody today to give you a definition of a natural-born citizen, you get 90% wrong answers. You
And
say
it's-
it depends
and
where you're born.
Yeah, well, if one of them is an American, et cetera, you can. So there's what we call is if the pregnant woman, the baby is, even though she's not a citizen, born in the United States. Those are things that originally weren't in the Constitution. Those are some very fast and loose interpretations that we allow the court to get away with. So, but you touched on something that I think is hitting the national scene that's so important. About 25 years ago, I wrote it's about a 20-page paper discussing this idea of that we lost the definition of the term citizenship. Citizen, as what it was originally meant in the 14th Amendment and the other amendments prior, just after the Civil War, we had corrupted the term. And we had lost the distinction between a civil right versus an inalienable right, these kind of things. So everything gets jumbled up. So it's very hard if you don't have a clear definition of citizen and you don't understand civil rights, inalienable rights, these kind of things, to draw a jurisdictional line and be able to declare this is and this isn't. We were already fuzzy 25, 30 years ago on the very definition of citizen, the way the court was manipulating the 14th and particularly the 14th and 15th Amendment. So it's interesting what is going on. We have lost that precision, but remember that it's tied to the culture of the people. If the people become corrupt, just like you see people, oh, my son can do that. Have you ever had a fellow colleague that they parent so loosely with their children, it's not that's not a big deal, and you're so strict? What it has to do with their character, right? Well, the same thing for a nation. If the nation has loose character, all of a sudden the precision of words become fuzzy. You see? So we're seeing that as a reflection of ultimately we get the government that mentions our character in many ways. We've been fortunate that we've been buying time for a long time. Yes.
At the level of law schools,
Yes.
professors
Yes.
who are fully aware of what you showed
Yes.
was 25 can they imagine that when they are fully dominant, they will have no transcendent appeal, even theoretically, among their own dispute? It will only be a war of all against all. The various identity groups,
Right.
etc. Can they think that far ahead, or is that?
They can, but they don't worry about it because there's a drunkenness that comes with power and authority, So they get to be king even if it's for a day. And we always think that nothing bad's going to happen to us anyway. You see, when we start thinking about ideas that people, without getting into transcendent things, that people just want limited government, there's a philosophy and a worldview that comes from. And that's gone to at least a younger generation. So we have a real battle because not only are we saying we want a particular philosophy and interpretation, we've got a problem that's just developed right under our nose in the last 20 years. It's starting to show itself. We don't have any. What are you talking about? Words don't mean anything anymore. Yeah, that's a whole different animal altogether. And what I think that all of us can come together, whether one is conservative, liberal, libertarian, if you are a patriot and love your country, then we can all come together and say, this is something that none of us survive from. Again, they call it deconstruction. When they look at a literary text, it literally is a giant wrecking ball that knows only how to destroy but never to rebuild. And we're all will sink in that boat together. So we do have something in common to share. Yes, sir.
Yeah. I rely on one thing in the Constitution, Article 6. Forget the money part and go to the Supreme Law.
Yes.
Okay. I'm fighting this in court cases all over the damn state. Anyway, Supreme Law says the Constitution, statutes, treaties made of that date may be made, okay, of the Supreme Law of the land.
Yes,
Each
but see,
question-
you presuppose integrity that the whole they can redefine it. They can supreme law is what? We'll say, well, we the people. It says, well, yeah, we the people, but it's the supreme law of the land can now what? Be subject to the people, but the people now, we're not talking about national borders. You see what I mean?
Right.
So it's redefined, and as what is the supreme law? Supreme law now is subject to the consensus of a very wide group. So they'll not hold to the integrity of those very words.
When I look at the
Yep.
values of
After you're
justice,
finished, we'll have time for one more question.
I don't know to.
No, go ahead. Finish up, and we'll have time for one more question, and then we have to.
The biggest problem that we suffer from in this country is lackadaisical people who know it's wrong and just say, let Joe handle it. Because I'm in right now, I'm filing complaints against judges in the federal court in Boston because they do not read the statute. They read into the statute. They read out of the statute. And if they do that, they're in violation of all these things that the Supreme Court has said. The legislature says in a statute what it means and means what it says. Also, under 2 and 3, I have the court cases. The judge is not allowed to read into or read out of. Okay? He has to say, shall means I will do it. It doesn't mean, oh, I don't have to do it. I'm going to do what I think.
You know, what is happening though is that
That's
you're
what's happening.
right in principle, but you also have to have people on the bench that honor the integrity to give substance to those words, and sometimes they simply don't, because if they're left to their own interpretations rather than being bound by what is in the written text, you may get individuals that you can read exactly what the law is, but they'll tell you they're just not going to rule in that way. So there's integrity. Again, we're back to where are we at as a people will tell you what kind of corruption happens within the nature of language and within the nature of what we call duty that you're supposed to uphold as a judge.
Last question.
I have a question for you from Joey from New York City. He asked, do you think that if the Democrats take control of Congress this fall, they will form a rogue branch of government, and are the checks and balances in the Constitution strong enough to stop them?
Well, theoretically, see, this is where I just got to be careful. The brilliance of the Constitution is that yes, the structure is there to prevent something like this. However, will men and women who have sworn an oath to defend the Constitution or uphold the Constitution actually do their constitutional duty? So it all hangs in the balance. The bottom line is that the Constitution is an external document. The spirit of it is given by the very unction and the standards of the people that swear allegiance to it. And if they don't really believe in it, they believe that they have a better idea about how to run the government or what should be done, and there's enough of them, the Constitution goes by the wayside. You know, there are things that are happening today in the news that should cause an outrage or not cause an outrage. So why is that?
Thank you, Rod.
All right, thank you.
Good night,
I'm done. Thanks, guys.
Yeah, can I have your attention for a second, please?
I'm speaking on behalf of the group and I'm cost. Mr. Tea Party.
Why don't you come up?
The Worcester Tea Party is going to be out in force at the state convention in 2 weeks, because it's in their neighborhood. And they have a little project, and I suspect some of you are delegates, just like I am, all right? They want to circulate a petition. What they want the petition to say is get Charlie Baker to sign off on opposing the millionaire's tax. Charlie Baker is the kind of politician who would just as soon avoid that altogether and go with the flow. It's the genius of this is not a confrontational thing. We're not running against Charlie. We're not trying to create an insurgency campaign. We're just trying to stiffen his spine a little bit on a subject that he knows that if you support it would take a serious dent in his base of support, tenuous as it is, but he doesn't want to anger the establishment as well. So the petition will be out there. If you go to the Worcester Tea Party or the Facebook page, you can look at it. People sign up on the petition. They may generate enough noise that something gets done about it during the convention. It's a pretty obvious ploy, but it's a sensible one. It's a citizen's petition. It's the way these things ought to work. So just go and take a look.